next matter to come before the court this morning is Thomas M. Presper versus Jesse Hurst. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you'd like to reserve any time for rebuttal, if you let me know, then I can keep the clock appropriately, although you'll notice we have this up here. You've probably been a part of that before. This is my first time operating that, so be forewarned. Right? We have read the briefs, so we're ready to see who you are.
Yeah, please, the court, Mr. Matisich. Your Honors. My name is Orville Reed for the record, and I represent the appellant in this case, Thomas Presper and Presper Financial Architects. I know the court has read the briefs and understands the issues. I believe that the question that has to be answered by the court in this case is this. Can this court, or can the law, absolve, forgive, and condone the conduct of Mr. Hurst in walking away from a contractual obligation to pay to Mr. Presper 1/2 of the rent due and owing for the space at Canal Place A that was leased originally by Millennial Group LLC. That's the issue before the court. The trial court endorsed the reasons asserted by Mr. Hurst in defense of his position to walk away from his obligation, and I would suggest that the trial court's decision is a supreme victory of form over substance.
Counsel, one of the arguments that they made was that Canal Place, and I don't know exactly what the end letters are of Canal Place, whoever it was at that point, had indicated to him that they might require a new lease, that they might require a new person, that this would not be under Millennial anymore. So they're saying, well, you could have made provision for that in your release, in your contract.
Well, Your Honor, there's no question about the fact that the lease obligation that was eventually signed by Presper Financial Group and Presper Financial Architects and by Mr. Presper personally as a guarantor, it is a new document. There's no question about that. But I think the underlying question is does it carry the same obligations? Does it carry the same obligations? And I know there's going to be a dispute about that as well.
Right.
But does it carry the same obligations? And does it, when the termination agreement is read as a whole, does it warrant the relief to which the trial court accorded Mr. Hurst?
But what they're saying, I think, is you knew you might have to sign a new lease because, quite frankly, that don't make sense. Okay. So you knew you might have to sign a new lease, so why would you make provision for that?
Well, Your Honor, I think that the answer to that is that Mr. Presper believed that he was basically carrying out the same obligations that he had under the old lease, the Third Amendment lease that was executed in 2013 to the original 2002 lease, and that he was doing nothing more. As a matter of fact, as the court knows from reading the record, what he asked for was a change of name of the lessee from Millennial Group LLC to Presper Financial Architects LLC. The lessor, Canal Place A Ltd. at that time said, no, you can't do that because of the various changes. And Your Honor, I suppose that's a question to be asked and answered as best I can. I think the obligations were the same, and that's why I believe, Your Honor, we're talking about form over substance here. The obligations are the same. He did not rent any more space than was rented under the original lease between Canal Place Ltd. or Canal Place LLC and Millennial Group LLC. He has the same amount of space at the same rate per square foot, exactly the same. And I think, Your Honor, that answers the question as best we can give it. It's a legitimate question. But the question is whether or not, even assuming that they should have done something, what does this termination agreement provide? And does it allow Mr. Hurst to walk away from his obligations under its terms? The termination agreement imposes an overriding obligation on Mr. Presper, and that is this. Presper, or an entity owned by him, will continue to occupy the premises from and after the effective date, and Hurst will continue to pay 1/2 of the remaining monthly rent due under the lease until the soonest to occur of, then there's 4 conditions, four conditions subsequent that need to be discussed. But there's no question that the overriding obligation imposed upon Mr. Presper was to take over the space that had been previously occupied by the Millennium Group. The trial court said, Mr. Hurst argued, and the trial court endorsed his arguments and said that the lessor has changed, the lessee has changed. But the court knows, this court knows, and the trial court knew as well from the arguments that were made there, that in fact, the anticipated course of conduct was to dissolve and liquidate the Millennium Group. Millennium Group was not going to remain on the lease. It was to be dissolved and liquidated pursuant to the terms of paragraph 1 of the termination agreement. Furthermore, paragraph 7 provides that Millennium Group, the name Millennium Group, could not be used by either party, Hurst or Presper, after the date of the termination agreement in June of 2017. So there is no conceivable way that the lessee on this contract could be the same. Millennium Group was to be dissolved and liquidated, and Mr. Hurst, in fact, took it upon himself the obligation to file a certificate of dissolution and liquidation with the state of Ohio, as you will see, I believe, in paragraph 1. So there's no conceivable way that it makes any difference at all with the lessee. It was Presper or an entity owned by him who was going to receive the benefit of payments to be made by Mr. Hurst. The second argument is that, again, the parties have changed, so the contract was terminated. The other party to the contract, Your Honor,
Would there have been an obligation, you said the parties changed to the contract terminated, was there any obligation on Mr. Presper's part to continue to remain in that space at that point?
Your Honor, somebody was going to get sued because the lease was in effect. Somebody had to stay and make the payments, or there was going to be a lawsuit. And Presper and Hurst were both personally obligated under the terms of that lease. So that was the risk picture. They could have both walked away, sure. And there was going to be a huge lawsuit, and it was probably going to result in a judgment of over $200,000. So could they have walked away? Yes. Were there consequences? Serious consequences, Your Honor. Okay, so the court says the lessor changed too, because under the original 2002 lease, and even under the amendment in 2013, the original lessor was Canal Place A Limited, Ltd. However, there is a reference in the termination agreement to Exhibit H, and that Exhibit H sets out the square footage and the amount to be paid under the terms of the amendment in 2013. But you'll note that in that amendment, it's clear that the lessor at that time was not, even before the termination agreement was signed, the lessor was not Canal Place A Limited, it was Canal Place A LLC. The lessor had changed prior to even the termination of this agreement. So for the argument to be made, as it has been, that the lessor and the lessee changed are frivolous arguments, meaningless, and should not drive this court's decision nor the trial court's decision. The lessee had to change because the lessee was going to be dissolved and liquidated, and no one had the right to use the name Millennium Group. Wholly apart from the fact that the lessor, Canal Place, was not going to agree to have a liquidated company as a lessee in its premises. But secondly, the lessor had already changed, and that was known to the parties in its reference in Exhibit H to the termination agreement. So those arguments are meaningless, they are baseless, and it's a matter of form over substance. The next question is was the agreement that was amended in 2013 as the Third Amendment agreement, was that agreement terminated? And I would submit to the court that it was not terminated. It was restated in this new agreement that exists between Presper Financial Architects and Canal Place LLC. And the reason I say that is because the terms are exactly the same, with the exception of course, the CAM, which we'll talk about, and also the 2-month extension, which we'll talk about. So the question is, was that contract terminated? Now, it's curious the word is used there as terminated, Because termination means one thing in the lease agreement that existed at all times between Millennial Group and also the folks at Canal Place. And it meant this: outrageous conduct on the part of the lessee that allowed the lessor, and only the lessor, could terminate the contract. Only the lessor could terminate the contract for certain things: bankruptcy, insolvency, and outrageous change of conditions in the premises. And I address your attention to 18.01, 02, and 03 of the lease agreement that discusses termination and what termination means. So there's no question this was not terminated in the sense that the lease discusses termination. So I would submit to the court, what we have here is a restatement of the original obligation with changes to the CAM and also changes to the length of the contract. But it was not terminated as described in the lease agreement itself. The lessee has no power whatsoever to terminate a lease. Only the lessor, in this case Canal, can terminate an agreement. So this agreement was not terminated. It was restated, and the new parties were Canal Place, Ltd., and of course, Presper Financial Group.
And I'm going to alert you to the fact you have about 4 minutes remaining.
Thank you, Your Honor. Could I, at this late date, ask for 2 minutes?
Yes.
Okay, thank you. I'm sensitive to waiver. Your Honor, now let's talk about the extension, the 2-month extension. The contract provides, in the conditions subsequent, that if Presper leaves the premises, Hurst is under no obligation to continue making his 1/2 payments, which amounted to, over the course of the next 2.5 years, 3 years really, was over $100,000. So he has been relieved of an obligation for over $100,000 on the basis of these defenses that he's asserted. But it was the obligation of Tom Presper, that he had to stay there, he couldn't sublet, and the lease had to be terminated. I would submit to the court it was not terminated. It was restated in this new document, which sets forth the precise amount of square footage that Millennial Group had, that's what Presper Financial Group has, at the same rate. The difference, of course, is in the CAM, the Common Area Maintenance Fee. It is up in the second agreement. But however, that is a distinction that exists in all the contracts. The maintenance fee can go up depending upon the total amount of space that Canal Place is able to rent. The fact that the CAM went up in the second contract is only a reflection of the fact that someone left Canal Place as a lessee, and so they were occupying a greater percentage of the actual leased property.
But could that go up during the course of an existing lease?
It did go up, Your Honor, from time to time.
Okay, so the fact that they entered into, I'm just going to call it a different lease instead of a new lease or anything else, was not necessarily the cause of the maintenance fees going up.
That's what I'm saying, Your Honor.
Because you could have done that according to the lease,
That's right.
anytime your maintenance fees could go up.
That's right, Your
You're
Honor.
under a lease for a certain amount of money.
That's right, Your Honor. And that testimony comes from Steve Stoner, who was the property manager who testified in this case.
And Council,
It's part of the record.
just
My 2 minutes. And finally, the 2-month extension. Under the extension, you can document for this, Your Honor. The 2-month extension is, it was not requested by Tom. He did nothing to cause it. He did sign the agreement. The agreement doesn't say that. That if you sign the agreement, it says he has to cause the extension. He did not ask for the extension. He did not request the extension. He did not negotiate for it. And again, Mr. Stoner agrees that that never happened. So I would submit to the court that the case should be reversed. There are issues of fact here, and they should be resolved by a jury. We may lose the case. We may lose the case, but we should lose to a jury. We should not lose on the basis of summary judgment. I think it's inappropriate. I'd ask the court to reverse. Thank you very much.
May it please the court, my name is Michael Matisich, attorney for Jesse Hurst, who's with me. He's here sitting in the back. I'd like to use my time to address some points that Mr. Reed made, and also, of course, answer any questions for the court. Mr. Reed started by saying the question in this case is whether the law can absolve Mr. Hurst for walking away from his obligations under the termination agreement. It's not actually what the issue is. What Mr. Presper is trying to do and what the issue is can Mr. Presper reel Mr. Hurst back into this contract, which says his obligations have terminated. And that's what he's trying to do. This is not an issue of form over substance. It's an issue of law over Mr. Presper's attempt to judicially modify a clear and unambiguous contract between the parties.
Counsel, one of the things you argued is what I had already discussed with opposing counsel, and that is that that with the, where's my train of thought?
So with respect to the opportunity to renegotiate the terms of the termination agreement?
Yes, and you said, well, he knew in advance, thank you, because somebody didn't tell me. So you had said in your opposing brief that he had the opportunity, he knew in advance, so he had an opportunity to negotiate that.
That's correct.
Okay. Didn't your client know that too?
Yes, he did, Your Honor.
So he was aware of what may happen as well, as a matter of fact, what could happen, and still didn't do anything about it either.
Well, it
He
wasn't.
entered into that agreement.
That's correct, Your Honor.
So neither side really addressed specifically that.
So Mr. Hurst's position was, I've negotiated this termination agreement. We ultimately don't know what the landlord is going to do. It's possible that he could, instead of just assigning the lease to Mr. Presper's new entity, doing a sublease, which is what the parties expected to happen. They didn't expect him to let the Millennial Group off the hook altogether, even though it was going to be dissolved. They handled it through a sublease or assignment, which Mr. Presper even testified he expected would keep the Millennial Group lease in place, the personal guarantees in place. So that was a possibility. There was a possibility of a brand new lease agreement. And that possibility came up as they were negotiating the termination agreement. Mr. Hurst was looking out for his own interests. He testified, look, as long as the Millennial Group lease is in place and my personal guarantees in place, then I'll continue to pay half the rent. But once the Millennial Group lease terminates and once my personal guarantee terminates, then I'm not going to continue paying rent for Mr. Presper's company. It was incumbent upon Mr. Presper to change the terms, renegotiate the terms, shouldn't say renegotiate, negotiate the terms of Section 4 of the termination agreement to protect him if, in fact, the landlord ultimately wanted a brand new lease. And that's, in fact, what happened. But he didn't do that.
And both sides knew that was a possibility, you're saying?
That's correct, Your Honor.
That leads me to the other question, follow-up question on that. It sounds like then an argument could be made is almost illusory because you know the landlord's going to keep on a lease a corporation that's been dissolved.
Well, that's interesting, Your Honor. So the testimony in the case, including from Mr. Stoner and from Mr. Presper and from Mr. Hurst, and it's documented, is that the expectation was Mr. Presper and Mr. Hurst that they were going to keep the lease in place. They were just going to substitute Mr. Presper's new entity in place of Millennial Group, or as I mentioned, do it through, for example, a sublease, which would keep the Millennial Group lease in place. And that's clear Ohio law. Personal guarantees in place. Mr. Presper asked, I just want a name change. The landlord said, we'll do just an assignment, or we might need a brand new lease agreement. And then he looked at it and said, Mr. Presper, not to Mr. Hurst, Mr. Presper, this is more than just a name change that you're asking for. We're going to need you to sign a brand new lease and a brand new personal guarantee. Again, that was before the termination agreement was ever
And
finalized.
counsel, this is all extrinsic of the actual contract, correct?
That's correct.
And the court found that the contract was not ambiguous,
That's
so
correct.
none of this extrinsic testimony was relevant to the trial court's decision, or was it?
It's not, and thank you for bringing me back to my overall theme. That's the point, Your Honor. The material facts are undisputed. We have a negotiated termination agreement. And the termination agreement itself is clear and unambiguous, which the trial court found.
Okay, so let's stop there and say the trial court found it extrinsic, but then went on to find that plaintiff caused the lease to be extended.
I'm sorry, Your Honor?
The trial court found that the contract was clear and unambiguous, and then went on to find that the plaintiff caused the lease extension.
Correct.
Isn't that an additional finding that would require some determination of the facts surrounding what happened in this case?
Well, Your Honor, that's really only one of 4 grounds which requires judgment as a matter of law in favor of Mr. Hurst. It's in fact the 3rd in the order of our arguments. In that termination provision about the Millennium Group lease, it also provides Mr. Presper shall not cause an extension of the term of the lease. Mr. Presper is going to argue that the Presper financial lease, which does have different terms, is really just the Millennium Group lease on different paper. Well, then he violated that provision that says he won't cause an extension of the lease because he signed a new lease that extended it by 2 months. And now he's trying to hold Mr. Hurst responsible for 2 additional months' worth of rent. He argues that, well, I didn't ask for the extension, the landlord put it in there. Well, he still caused it by executing the lease. Regardless of who puts it in there to begin with, you still need 2 parties to sign an agreement to cause an extension of the lease.
What would have happened if Hurst had just said, or I'm sorry, not Hurst, Presper had just said, no, I'm not gonna do that. I'm not gonna sign a new lease.
Don't know, Your Honor, because he did.
Well, if he didn't, and they sued, what would your position be?
Position,
As to your client being responsible for half the rent?
well, the Millennium Group lease would have been in place then, Your Honor, because there would not have been this subsequent brand new lease agreement.
Except that the landlord may not have accepted that. That's basically what he said, right? I'm not gonna accept this. You're not gonna stay here under the Millennial Group lease.
The landlord said, we'll look at an assignment, or you may need to sign a new lease. The landlord said, ultimately, you need to sign a new lease. Termination agreement provides, plainly and unambiguously, that upon termination of that lease, the Millennium Group lease, that Mr. Hurst's obligation to continue paying rent terminates. So, if we can just boil it back down to the core issues, again, we have a clear and unambiguous contract. And we have undisputed material facts that the Millennium Group lease terminated. If you read through the briefs, both at this level and at the trial court level, we cited a number of cases involving situations and arguments just like this. And the courts have said, on a variety of grounds, that there was this new subsequent lease caused a termination of the original lease. It was the Renaissance case, there was a case from the 9th District, and 2 other cases. But they all, in essence, involve the same principles. You had an original lease, then you had a subsequent lease. And at issue was whether the subsequent lease terminated the original lease. And in every one of those cases, and we cite them all and we quote some of them, the courts say when the parties execute a new lease, it terminates the original lease. They also dealt with, I think in every one of these cases, an argument that, well, the second lease is really just, an extension or an assignment or a continuation of the first lease. And all of those courts said, it's not. And in any event, when you change the terms under the second lease, the first lease still terminates, whether you call it an assignment or even if the paper itself says it's an assignment lease, if you change the terms, it terminates the obligations under the original lease.
When I'm listening to your argument, it sounds like you're just saying this is just a straight issue of law.
It is, Your Honor.
Okay. If that's the case, then why do we need, you have to have facts to determine what constitutes a change. You'd have to have somebody come in and talk about how it changed and, what the requirements were and so forth. And you also made the argument about, and I know it's extraneous, but you made the argument about what the landlord and the tenants were negotiating beforehand in regard to the whole dissolution and settlement. So those facts all seem to come into play.
Well, those latter facts, no, Your Honor, I was
Okay.
addressing them because they came up.
Okay, well, you mentioned it in your brief. But
As far as the changes go, if you look at some of those cases, like the Renaissance case that I mentioned, the 9th District case, the courts ruled on those issues. Norris was a summary judgment case. And there's two.
But that just means that there, in that case, there may not have been issues of fact.
That's true, and they're not here, Your Honor.
But that's
Because-
different whether you have to look at the facts.
Well, it is, but argument number one is this is a separate lease document, which terminates the original lease document. It's not an extension or an assignment or a continuation. There's no mention of the Millennial Group lease and the Presper Financial lease. In fact, it contains an integration clause that says this is the entire agreement, and it supersedes all prior agreements and understandings. That is a separate ground. That's number one primary ground for holding, and the courts have held as a matter of law, that terminates the original lease. Argument number two, even if somebody wants to argue it's an assignment, it's not when you change the terms, and particularly when you increase the burden upon the original party under the original lease, which here would be Mr. Hurst. So that occurred as well. Extended the term of the lease. The gross rent is higher. The CAM did go up and down under the lease, but we're talking about the percentage of CAM that the tenant's responsible for. It was like 0.3% in the original lease, and it's now 0.4% in the Presper Financial lease, which is like a 25% increase in the CAM charges. It's for a longer duration, so Mr. Hurst is now supposed to be obligated under the Presper lease for an additional period of time. Courts have said, under those circumstances, there is no issue of fact. It's still, as a matter of law, not an assignment because of those things, even if you want to call it an assignment. Then you've got the third argument, which is that Mr. Presper should not cause an extension of the lease term, which we've already addressed.
So you're saying that all these facts that we're talking about that were not disputed by either side?
That's correct, Your Honor. The material facts are not disputed. You can't dispute that you have a termination agreement. Everybody agrees. You can't dispute that we had our original Millennial Group lease and it says what it does. And you can't dispute that you have a press release that says what it does. And that's all we really need to look at, Your Honor. You apply that to the law that we cited in the brief, and it requires a conclusion that the first lease, the Millennial Group lease, terminated as a matter of law for, I think, four independent grounds.
I think it's still in dispute, is it not, that whether or not Presper caused the extension of the lease?
That would be one of the grounds. And my response.
Material?
I'm sorry?
Is it material such that that one ground, I understand that there are several that precede this. I'm just trying to understand the argument with respect to this one thing that the trial court found, which was that Mr. Presper caused the extension. Just, it's in the opinion, but it's not, it doesn't matter, that finding, because it's not material.
Well, I believe implicit within the court's decision is that he caused an extension of the lease because he executed the lease with a longer term. By executing it, he caused a longer extension. Does it matter who asked or who put it into the document? It doesn't, because you need two parties to cause an extension of the lease term, whether Mr. Presper asked for it or the landlord asked for it. Imagine if the landlord had come to Mr. Presper and said, we're going to tack on 2 years to your lease agreement. Or we're not going to, let you stay here, whatever it might be. And he says, okay, well, I didn't ask for it. And he signs it anyways. Does that mean now that Mr. Hurst is responsible for another 2 years worth of rent? That can't be the result. He caused it by signing. I have about 40 seconds left. Does the court have any other questions?
Seeing none, thank you.
Thank you.
Do I actually have a full minute and 12 seconds, Ron?
Okay, thank you.
Your Honors, I would like to say a couple things. Mr. Matisich wins the reductio ad absurdum argument. This is not a 2-year extension. It's a 2-month extension that was not asked for. And that's what we have to talk about here today. Again, I maintain that this is a case, a decision that puts absolute preference to form over substance. And And I would suggest we should leave that protocol to ambassadors and diplomats, and this court should deal with substance. The other thing I want to say is this, before Judge Hensel reminded us that this was here on summary judgment and extraneous evidence was not an issue, Mr. Madison said Mr. Hurst wanted to be off the lease, and once he was off the lease, he wasn't going to pay anymore. Well, I would submit, Your Honors, that if that were the important thing to him, to be off the lease as a guarantor, there would have been 5 conditions subsequent in paragraph 4. But instead, it's if Tom leaves, if he sublets, if the lease is terminated, or if it's extended at his request or at his doing. And but there's nothing in there that says if I am lifted off that initial agreement as a guarantor, then all bets are off and I'm walking away from this. It doesn't say that. They're the ones who want to rewrite this contract. All we're saying is there's extraneous evidence that needs to be submitted to the court, and a jury should decide this case.
Thank you.
And I thank you for your time.
Thank you both for very good presentations today. The court will take the matter under advisement. We will issue a decision which will be sent to both parties as well as posted on our website and the Supreme Court website. Thank you both.
Thank you.